Hello everyone, I'm Sanya Agrawal and I'm back with another video on place of sewing under CPC. If you have not subscribed to my channel legally still now, please subscribe to the channel so that you will get updates regarding the new videos that I'm making and I'll keep making in these classes or in this playlist on CPC. One important announcement there I have in the last videos covered the topic of res judicata and res sub judice and the meaning and the details of constructive res judicata. But there are certain important concepts related to res judicata like how it is different from estoppel, how res judicata is applicable on compromise decree, in ex parte decrees, on writ petitions. So if you want me to discuss all the small topics related to res judicata that are not directly mentioned under the barrack of the CPC, but is interpreted by the court in different cases and has become a part of Section 11. Please let me know on the comment section and I will make those videos and explain all those things. Also, if you are interested in such videos, mention the topic that you want me to cover. I'll make those videos on those topics and so that it will help you in understanding those topics in a better way. So, this was just an announcement. Now, moving again to the topic that we are going to discuss today, that is the place of suing. Place of suing under CPC is basically related to the concept of the territorial jurisdiction, subject matter jurisdiction, that when a particular suit is filed, then according to the Civil Codes Act of every state, the case goes to that particular court and that which particular court will have jurisdiction over a particular territory, the pecuniary jurisdiction, all this is given under the Civil Codes Act of every state. But there are certain central provisions that are related to the jurisdiction when the property you are, let's suppose the property is situated in one particular area and the court has a jurisdiction over it as per the Civil Codes Act. But this particular property can be covered under Code 1, Code 2, and let's suppose some part comes under Code 3. Or if you are not clear that there is any particular court which has a jurisdiction over this particular property, or there is an immovable property, how will you determine the jurisdiction over that particular property? If there is a movable property, how will you determine the jurisdiction over that particular property? So there are a lot of questions related to it, and these questions generally are answered from section 15 to section 20 of the CPC. Moving first of all to section 15. Section 15 is a very general provision and it says that the suits should be filed in the court with of the lowest grade. So let's suppose there is a particular property which comes within the territorial jurisdiction, pecuniary jurisdiction, and subject matter jurisdiction of junior division court plus senior division court plus district court plus high court. Then which court will be the court competent to try it? So all the courts have the competency as per these three jurisdictions. But where will you approach? You will approach to the junior division court and not any other court, because section 15 says that the lowest court which has the competency should be the one where you will be filing the particular suit. So that's why you will be moving to the junior division court. If let's suppose the junior division court did not have the jurisdiction and only the senior division, district court or high court has the jurisdiction, then you will be moving to the senior division court and not any other court. So this is what is given under the section 15 of CPC. Moving ahead with the section 16. Section 16 talk about the jurisdiction of the court in the cases wherein the property is a immovable property, or even if it is a movable property, it is attached to a particular place, and that's why you are considering it as a movable property. Okay. Yeah. So it says subject to the pecuniary and other limits prescribed by law, suits to be instituted where the subject matter is situated. So, first of all, these 6 points are provided that in these 6 points, the property will be decided on the basis of the place where the property or the subject matter is situated. So the first case is when the case is related to the recovery of immovable property. If there is a immovable property, let's suppose there is a house and somebody else has a possession of the house, to recover back the possession, you can file a suit at a place where this immovable property or the house is located. So that court will have the jurisdiction. यहाँ पे with and without rent or profit लिखा हुआ है, so you can claim it from a person who is a tenant who has responsibility to give you rent, or even if you do not want a rent or rent is not due, then also the same rule will be applicable. Or profits, for example, if there is a person who is in wrongful possession and from whom you can claim as a profit, or even if you cannot claim as a profit, that is again immaterial. So if rent can be claimed or not claimed, profit can be claimed or not claimed, that will not change the fact of the jurisdiction of the court. It will be filed in a place where the immovable property is located. So similarly, a case related to partition of immovable property will also be filed in that place जहाँ पे property situated है. Foreclosure, sale of redemption in a mortgage property or charge on an immovable property. Foreclosure is basically a right to get the property by the mortgagor when the money is not paid by the mortgage. When the money is not paid by the mortgagor, the mortgagee can foreclose the property. Redemption is that the mortgagor can after making the whole payment take back his property. So all those cases will be filed in that court where that immovable property is situated. For determination of any right or interest in the immovable property, for example, you have a right to sunlight, or you have a right of path, or you have a right of air. So whatever the right you are claiming through the immovable property, that particular right can also be claimed in that court which has the jurisdiction over that immovable property where the property is situated. Or compensation for wrong to an immovable property, if somebody has damaged a part of your immovable property, like somebody was doing construction in the neighborhood and because of that some material fell into your property and damaged your property, so again the suit can be filed in a place where the immovable property, where the property which is damaged is located. For recovery of a movable property, actually under distraint or attachment. So if a movable property is attached by the court or under distraint, then also you can file a suit in a place where the movable property is actually present or situated where it was attached. So on all these cases, the place, the location of the property matters, and that place where the property is situated or located, that court will have the jurisdiction. So the suit shall be instituted in the court within the local limits of whose jurisdiction the property is situated. In all these cases, the property, the jurisdiction will be decided on the basis of the place where the property is situated. Now, a proviso is also given here. This particular proviso is important because it is talking about a case wherein the case is related, the suit is related to the compensation or wrong to an immovable property, and the relief can be claimed entirely through the personal obedience of the defendant. Let me explain this point. For example, there is like one of the point was that there is a wrong to the immovable property. So wrong to the immovable property, matlab, let's suppose again there is a damage to the immovable property. Now you want to claim the amount for the damages. So again, when you are claiming the amount, you do not want anything from you do not want him to repair the property. You just want to claim the damages. So let's suppose A was the owner of the property, B was the person who has caused the damage of the property. A want the damages and the compensation. Okay, but he is not asking B to do the repairing work over the property. So इस case में A को जब damages चाहिए, that means he just want an amount from B. When he is asking for an amount, B can give this amount either from his property or by his personal obedience as well. Personal obedience means that he can himself also fulfill that particular degree of the amount without even touching his property. वो या तो अपनी किसी और property, किसी और immovable property, या फिर किसी और movable property, या फिर अपनी salary, या अपना कोई और profit, या अपना कोई saving या investment कहीं से भी वो उस amount को लाके दे सकता है अगर उसके अगेंस्ट डिग्री आती है. So there is no need of attaching the property or filing a suit in a place where only the property is situated. It can be filed in any other place where you can find the defendant. So that is why यहाँ पे लिखा हुआ है कि अगर पर्सनल ओबीडियंस से आप उसकी प्रॉपर्टी आप अपना रिलीफ एंटायर रिलीफ इट शुड नॉट बी लाइक पार्ट ऑफ द रिलीफ यू कैन क्लेम फॉर हिज पर्सनल ओबीडियंस if the entire relief which the plaintiff is asking for can be achieved or can be the plaintiff can get through the personal obedience of B, then in those cases the property or basically the decision, the suit will be filed in a case where the defendant is either actually or voluntarily residing, or defendant carries on business, or defendant personally works for gain. So if in any of these places the defendant either is actually, let's suppose defendant is residing with his own consent at a place and the property is situated at some other place, the suit can be filed at a place where he is residing, or he is carrying on his business or working for gain, that means वहाँ पे उसको कोई job वगैरह मिला है, तो all these places will have the jurisdiction. The property in this case should be situated in India, and we are not referring to a property situated outside India. Again, let's take an example. The property which was damaged was situated, or basically the house which was damaged was in Hyderabad, but the house of the plaintiff, that is A, was a guest house, and he was not living in that particular place. He used to live, or he lives in Pune. So if that is the case, he lives in Pune, and the defendant also lives in Pune, or defendant has a business in Pune, the plaintiff will find it convenient to file a case in Pune only, क्योंकि वहाँ पे defendant भी रहता है, defendant का भी business है, he also lives there, and he will not be able to go to the Hyderabad court whenever it is required. So he can file a suit even in Pune where the property is not situated, but the plaintiff can get the damages or can get the relief, entire relief from the personal obedience of the defendant, and that's why Pune court can also give a decision in favor of A.